The chair calls Mary Robinson as a resource witness. I know you've been with us all day, and just a couple of questions. Currently, under law, no medical doctor can make a recommendation of use of cannabis in any way. Is that correct?
Mary Robinson, Texas Medical Board Executive Director. That would possibly be considered a violation of the Act. Specifically, 053A1, sorry, it's late, 053A1 says that it is a violation of the Medical Practices Act to violate any state or federal law in connection with the practice of medicine. So if they were to promote the use of what is currently classified as an illegal drug and we actually received a complaint about that, then that would go through the disciplinary process. I'm not aware that we ever have, but certainly that would go through that same process. The language in the bill, though, would prevent that from being the case were the bill adopted.
Okay. Members' questions?
So you're saying that the way that the bill, because it's so tightly written and it's very comprehensive, so it seems like it's addressed all the concerns that we have for that issue. So the physician wouldn't face any disciplinary action nor any criminal action.
I can't say to you for sure how the criminal prosecutors would interpret this. I would say that the intent is fairly clear, but what is modified here is the Practice Act for their civil responsibilities under the Practice Act. So I'm not sure how that would go about the criminal aspect of the entire thing.
So you mean like they couldn't be sued for like a malpractice claim?
And they wouldn't be liable under their license. So the medical board would not take an action against them were this language to pass.
But you just, is it because you can't speak to the criminal portion because you don't handle that type of, you're not in that field? Okay.
That's accurate.
All right, but it's covered under your field though?
Absolutely. It would be covered under our field, and their medical license would not have any issues were this bill were to pass.
Good, thank you.
I have one quick question. What about the fact that it violates federal law, and the Act says that the physicians can't violate federal law? So even if this bill were to pass under state law, there might be state protections, but it still would be a violation of federal law. So could there be claims brought because of that?
Well, because the federal government doesn't enforce our Act, and this provides a state defense to any state prosecution, I still think that it would be fine within the confines of what we have set up right now. The federal government might not recognize it, but they don't have any jurisdiction over medical licensing.
Madam Chair?
Yeah, perfectly.
Thank you, Madam Chair. Ms. Robinson, I know you're not really trying to speak as an attorney overall, but just to follow up with Representative Davis's question, so if it's against federal law, the plant or the drug, whatever, but you have these states have legalized it, how does that work? If they've legalized it in the state, it's against federal law. I mean, we're pushing all these two against each other at this point, so how does that play out?
So just very high level, because obviously I'm not a specialist in criminal law, but at very high level, you've got different forms of prosecution across different strata. So you have federal prosecutors who are in our state right now who would prosecute anything that came to them as a federal crime. You would have state prosecutors for any state crime, and then civilly, you've got the medical board related specifically to the medical license. So a federal prosecutor, if they wanted to, could prosecute any individual in the state of Texas for violating a federal law, regardless of whether the state considered it to be illegal or not. It's just you haven't seen much of that happening as such in those states, but it doesn't mean that the federal government couldn't pick up and do it at any time if they wanted to.
So even with the passage of 594, the federal government still could be standing by doing their thing with regards to prosecution.
Sure, because the state doesn't have any authority to change the federal law, but what this would do would be to ensure that the physician's license, as far as Texas is concerned, would not be subject to prosecution.
Okay. And second question, I think I heard you say that you were not aware of any complaints to the CMB with regards to a physician you know, not so much promoting, but just saying, hey, this is an option, or I've heard that it might be helpful. You haven't had, in your experience or in your knowledge of the history, the medical board had any type of complaint with regards to this. Is that correct?
I am not aware of any in the past decade or so.
Do you know of any before? I mean, if it's ever happened?
No, I'm not aware of any period, but I haven't been there.
And your other colleagues throughout the country with regards to TMB, I don't know if you have an association, do you?
There is an association. There absolutely is an association of medical boards, and oddly enough, this was an issue that was brought up about how the other medical boards were trying to sort of integrate this, because several physicians have multiple licenses, and sort of how that was going to integrate, but they really had not, the discussion was really about, well, what could happen, but there hasn't been any subsequent discussion about anything negative actually happening. Okay. There hasn't been any sort of thing, there were concerns about what might happen, but I haven't heard anything, and we just had the annual conference actually in Boston 2 weeks ago about this.
Okay, so that would include the 18 states that have laws like this, and as well as the ones that have no laws. So but broadly, you didn't hear any issues with it. Okay.
No, ma'am, I did not.
Thank you.
Members, other questions?
Thank you, Mary.
Thank you.